Seems to me it might be time to make a start. Thank you everyone for coming and coming bright and early this morning. You'll have noticed the name of the seminar this morning is Trains, Tunnels and Toll Roads. Equally, probably it could have been more mundane matters such as parks, road widenings and roundabouts. But in any case, we want to talk about some of the mechanics in particular of the compulsory acquisition process. Having had a talk to a few people this morning and a look around the list, I noticed we've got a real mix of people for whom I'm guessing compulsory acquisition is not a large part of their practice or part of what they do every day. We also have some people here who, as far as I'm aware, spend pretty much all day, every day, doing compulsory acquisition. So you'll excuse us as we try to cater for both sides of the experience spectrum in our presentations this morning. You'll be aware that compulsory acquisition has achieved a certain amount of prominence even in the cultural lexicon by virtue of the castle. And you'll remember Dennis Denuto and his great implorings of the Supreme Court to consider the vibe and a man's castle is his home. In reality, certainly in my view, the situation in relation to compulsory acquisition couldn't be more different. There are probably few areas of law in which the vibe is less relevant, perhaps except in relation to sorting out a precise figure for solatium. But it's one of the most heavily regulated areas of law in Victoria, in my view. It's also an area in which you have two statutory overseers in many situations, both in terms of the Valuer General and the Government Land Monitor. So, sadly, without wanting to get in the way of good script writing, there's a big difference between the vibe and the way in which this area of law is practised. This morning we've got two speakers. The first is Tiphanie Acreman, who's going to give us an overview of the Act. And this is perhaps tailored more to those who don't do compulsory acquisition every day, and she's going to take you through the Land Acquisition and Compensation Act. We are, for the purposes of today, because we only have a short time, not going to delve into the compensation provisions in the Planning and Environment Act. That's something perhaps a topic for another day, and we're sticking pretty strictly to the Lacquer Act. Andrew Fraatz is then going to take up some of the more burning practical issues and to talk about selecting valuers, decisions you might make, and perhaps decisions that might be informed by some of the relatively recent cases in which the Supreme Court has been less than entirely charmed by the way in which some valuers have gone about their business. He's also going to talk about one of the most important issues in compulsory acquisition, in my view, which is offers and getting offers right. So we shall leave him to do that. The first of our speakers is Tiphanie. She practices in a broad range of fields. She does drafting and advice work and advises and appears in matters including much broader, obviously, than this area of law, including contractual disputes, property disputes. She has a practice in planning, as many of the people who work in compulsory acquisition do. She has experience in all manner of areas, including a relatively recent case in which she was responsible for stopping the John Faulkner Hospital from going ahead by raising one of those truly charming areas of law known as restrictive covenants, a very tricky and esoteric area of law which apparently enables you to argue invoking the part of the Planning and Environment Act that says if you're going to infringe a restrictive covenant, you can't get a planning permit. Apparently, by that means you can stop a hospital. Whether or not that's a great thing or not, what can be said is that she's an effective advocate on behalf of her client who moved apparently next door. Prior to coming to the bar, Tiphanie was an associate to the Honourable Justice Warren and later the Honourable Justice Judd of the Commercial Court. She holds a Bachelor of Law with first-class honours and a Bachelor of Science, majoring in Geography and Environmental Science, and is, I'm told, currently completing her Masters of Law. Lord knows how she finds the time. With that, can I ask you to give Tiphanie your attention?
Thanks, Sarah. Yeah, I think the clients in the hospital case were very happy. I don't think the hospital was, though. Whether that's a win for the community, I'm not sure. I'm going to be giving an overview of the Act today, and for those of you who practice in this area, you just have to bear with me. It's going to be a broad brushstroke of the steps in the process of compulsory acquisition, and if you've worked in the area a fair bit, then you'll know this part. To start with, prior to the acquisition process, land is reserved under either a public acquisition overlay or an Act. So, for example, for the regional rail link and for the east-west link, the process of approval is through the Major Transport Projects Facilitation Act. And that Act allows the Planning Minister to designate a project area. So whether or not the land is already the subject of a public acquisition overlay under the planning scheme, then this Act enables the Planning Minister to designate that a particular area is going to be the subject of a particular project. And the Major Transport Projects Facilitation Act, obviously, given its title, is designed to assist in getting these big transport projects up and running and providing a process by which they can be assessed, and then by which the acquisition process can begin more readily. Now, the next stage in the process of acquisition is that the authority, which will have been set up under the Act, so for example, in relation to the regional rail link, it's the Regional Rail Link Authority, really original name. The authority will issue a notice of intention to acquire. Now, this is not an offer to purchase, and it's not binding on the authority. It just indicates to the client that the authority is intending to purchase that piece of land or their interest in land, and that steps will be taken, or steps may be taken in the future to do that. Now, it just puts the client on notice. At this stage, there's no valuation evidence being presented by the authority, no certificate of valuation. It's simply identifying land that may be the subject of acquisition in the future. Importantly, Section 12 means that of the LAC Act indicates that once a notice of intention to acquire has been issued, then dealings on the land are restricted. So your client, if they've received a notice of intention, can't sell their property or make durable improvements on the property without the consent of the authority. So that may be able to still be done, but they would need to notify the relevant authority, and whether or not they would get the consent of the authority would be entirely dependent on the circumstances, where the land is, what the project is, and what the plans are in the future for that specific interest in land. It's important to remember, though, that in terms of acquisition of an interest in land, it's not just acquisition of the fee simple. There is compulsory acquisition in terms of lessees and other interests. So basically, it's acquisition of proprietary interests in land. So you may have a client who is the lessee. Perhaps they are running a business on a piece of land, and they have, a retail lease on that land. Then they have an interest in that property, and that is something that can be the subject of compulsory acquisition. as well as the fee simple. So the owner would need to sell their land as well. Once the notice of intention to acquire has been issued, after a period of time, and I'm not going to go through the periods of time that are covered in the Act, in particular in relation to compensation, there are a number of time limits that are quite specific, and they can, because of the back and forth nature of the compensation claim, they can get quite complex. So I'm going to leave to one side today the time limits, but after the notice of intention, then the next stage is a notice of acquisition will be issued under Section 19 of the Act. And the effect of this is that at the time that the notice of acquisition is gazetted, the property vests in the authority. So your client no longer owns their interest in that property, and then it's just a question of what compensation will be payable. And turning to compensation, the authority will make an initial offer of compensation, and Section 31 of the Act is the section that covers this. It's a fair and reasonable assessment of the amount of compensation based on the information the authority has, and it's usually accompanied by the certificate of valuation. Now, the authority won't have all of the information that your client has. They will make an offer based on the information that they have. So it's not necessarily, and quite often, in fact most often, not going to be the offer that ends up being agreed upon at the end of the process. So your client can either accept the offer or make a claim, and it's in making a claim that you gather together evidence to back up the parts of the claim that you say should be paid that the authority hasn't paid, and perhaps you disagree on the market value valuation as well. So it's at this stage that you are likely to get clients coming to you and saying, I've got this notice, what does it mean? They're offering to pay me X amount of dollars, and you will need to think carefully about what they can claim and how you're going to get evidence to back that up. And the earlier you do this, the better. So I'll get to the heads of claim and what you can claim shortly, but the earlier you think about how you're going to put the claim together, the better, because the stronger your evidence will be, and your clients will be working to that evidence in what they're doing along the way. Section 51 provides a process for advances of compensation. So the authority has made an initial offer. Even if you disagree with that, you can apply to the authority to have the compensation amount paid to the client. That's provided the initial offer was greater than $5,000. And if the authority later increases the offer, you can reapply and get the difference. So if the initial offer was, say, $10,000, you can apply and get that $10,000, and it's a without prejudice payment that says, the authority's paying what they say this is worth. You still have a right to disagree about the amount. Later on, when you're negotiating, perhaps the authority will increase their offer to $12,000. You can apply for that $2,000 to be advanced, and that means your client is getting the money straight up. And this means that obviously they're able to bank the money as soon as possible, and it's in some ways in the authority's interest to pay this. They have to under Section 51 if you apply, but if they don't, then they're paying interest, which is under Section... I can't remember the interest section. There's a section about penalty interest, which... whopping great interest. It is whopping great, 55, thank you. It's whopping great interest. It's 5% above penalty interest from memory. So the authority wants to pay that advance sooner rather than later. And if they don't, then you can get quite good interest on it. Quite good. Whopping good. So once the authority has made its initial claim, and perhaps you've applied for the authority has made its initial offer of compensation, and perhaps you've applied for it to be advanced, there is a process by which there's a back and forth of the claim. So your client makes a claim backed up with evidence. Perhaps you have some valuation evidence, which Andrew will go into more detail on, and the authority can then admit parts of the claim, revise and make re-offers or repeat their offer, and they can do that in relation to particular parts of the claim. So it might be that you'll have some parts of the claim agreed and other parts of the claim that are still disagreed, and if you still can't agree on those, then that part that's still in dispute becomes what's known under the Act as a disputed claim, and that part can end up going off to either VCAT or the Supreme Court, depending on where you decide to send it. Section 80 and 81 cover taking the disputed claim off to court or the tribunal. Just by the way, Section 37, by Section 37, if your client's entitled to claim compensation but the authority hasn't actually made an offer, didn't even get to initial offer stage, then you can actually make a claim as well. So if your client's been forgotten or the interest in land hasn't been noticed for some reason, then you can bring a claim on their behalf. So in terms of what can be claimed, Section 41 contains heads of claim, and these are the factors which regard is had in assessing the amount of compensation. If you don't have significant experience in this area, it's important that you get advice early on, because the heads of claim are complex. There's a lot of case law around this area and there's a lot of rules. And what you will get in the end will be in part based on the type of evidence that you can present, and knowing the best evidence to put forward and the evidence that's required is something that's important from an early stage. It also pays to seek advice early, because the pre-referral costs can be part of the compensation claim. So Section 41, subsection 1, paragraph F, says that you can also claim things like legal advice, reasonable legal advice that's necessarily incurred by the claimant as part of the process. And so that would cover advice from a solicitor or a barrister, the cost of getting the valuation on the property, and also some other professional expenses. It might be that you have planning permits that are approved and partially completed on the property, so therefore you might need to get some planning evidence from the town planner. It's important that the evidence is necessarily incurred, and it might be worth writing to the authority and getting them to confirm that they agree that such costs would be necessarily incurred if, for example, it's something like a town planning report. Initial advice from a solicitor or a barrister would generally be covered though, because that's something that really most people in the acquisition process would need, and it's reasonable for them to get legal advice and also evaluation. So don't be shy about getting advice, because it will become part of a compensation claim anyway, most likely, and the client won't have to pay for it. Now, Section 41(1)(a) is the part that the valuers are involved in particular. They're involved in all of it, but in particular, the valuers look at the market value of the interest on the date of the acquisition, and there is a case from which we get the willing but not anxious proviso. So the case is Spencer's case. It's Spencer and the Commonwealth, 1907, 5 CLR 418. Don't read it. You don't need to. The test is just, it's well known, and you don't need to read the whole case. I will read you part of it. Chief Justice Griffith said the test of the value of land is to be determined not by inquiring what price a man desiring to sell could actually have obtained for it on a given day, that is, whether there was in fact on that day a willing buyer, but by inquiring what would a man desiring to buy the land have had to pay for it on that day to a vendor willing to sell it for a fair price but not anxious to sell. So, willing but not anxious to sell, and assuming that there is a vendor available, not that there'd happen not to be anyone interested on that day, and that the purchaser available on that day, and that the vendor wasn't anxious to sell because the land was going to be acquired or didn't have to sell in a fire sale. And the test also assumes that the vendor and purchaser have the relevant knowledge of the factors that will affect the value of the land, so the prejudicial and also the advantageous circumstances particular to that piece of land. So that it assumes full knowledge. There is a lot of law and rules, as I say, around the heads of claim in section 41. I'm not going to go any further into them. Suffice to say that that can all be part of the advice if you choose to take it. So I suppose the take-home message is seek advice early, and the advice will be most likely part of the compensation claim in any case, so make sure that you seek it sooner rather than later. Thanks.
Thank you, Tiffany. Our second speaker is Andrew Fraatz, whose practice is largely concentrated in superior courts and commercial litigation, with an emphasis on major torts, personal injury, and in this area of law, land acquisition. He was involved in the long-running Love case, or at least parts of it. I don't think anyone was involved in all of it. For the claimant, he's also involved presently in some claimants acquisition cases for the regional rail link, which are on their way through the system, and various other acquisitions across Victoria. He's an experienced trial advocate with particular emphasis on appearing in and resolving complex interlocutory disputes. Prior to coming to the bar, he did articles with a boutique commercial property firm, where he had a broad federal and Supreme Court experience. He is going to speak to us today on matters arising from choosing your valuer, and also the important issue of offers and how to get those right and to use them most effectively for your client on either side.
Oh, thanks, Sarah and Tiffany, for that. As Sarah indicated, I'm going to talk to you about expert evidence, in particular valuers, and have a chat about some of the cases which have highlighted some of the problems people have had in trying to persuade tribunals of that particular expert view be accepted, and then also have a look at the various offers and so forth that are available in the land acquisition area. I will have a paper which will be distributed by email during the course of the day, so I hope that'll be a useful resource going forward. By way of overview, in terms of expert evidence, evidence of an opinion is not admissible to prove the existence of a fact about the existence of which the opinion was expressed. That's the opinion rule, which says unless an opinion is in substance an inference drawn or to be drawn from observed and communicable data. Now, the exception to the opinion rule, of course, is if a person has specialised knowledge based on a person's training, study or experience, and the opinion of that person is wholly or substantially based on that specialised knowledge, and that's Section 79 of the Evidence Act. I'll include as a schedule to the paper some what the High Court's had to say about that test and how it's been interpreted across the courts in Victoria as well. But suffice to say, in this jurisdiction, certainly so far as valuers are concerned, I mean, there's clearly an area of specialised knowledge. It really is the question of whether the opinion itself is wholly or substantially based on that knowledge, which is going to come into scrutiny, and that's the particular sales data, comparable sales, or other assumptions that they've relied upon in coming to a particular number for market value. And of course, expert evidence must also be relevant, and that's a very important aspect in consideration of some experts' evidence. Now, an expert, of course, has an overriding duty to assist the court impartially on matters relevant to the area of expertise of the witness. They're not to be advocates for a party, and the expert report must be transparent in providing the facts or assumptions upon which the expert opinion is based and the information relied upon. Our guiding principle must be that care has to be taken to avoid any communication with experts that may undermine or even appear to undermine the independence of the expert. So dealing with experts, in particular valuers, they must be kept at arm's length. I'd suggest that only formal communications concerning the brief are to be received, and the expert certainly shouldn't expect or receive any contact or initiate contact directly with experts. Casual emails will be discouraged. Emails are a way of life these days, but it's important. There are cases about this where the numbers were in the scores or even hundreds of emails were passed between advocates and solicitors and valuers and the client, and these all in a staged process can be exposed during the course of a trial and undermine the credibility and in fact the admissibility of expert evidence. Of course, under Section 122 and common law, privilege is waived upon the service of the report in relation to all instructions, communications and other facts and assumptions that the expert has relied upon to express the opinion. Now, it is not permissible in any way to settle the substance of an expert's report, even where it's provided in draft form. They must not be redrafted by lawyers. It is permissible for an expert, though, for example, to seek clarification of factual or legal matters relevant to an opinion, and also for the lawyers to be involved, of course, in the form of the report to ensure that it complies with the various rules as to admissibility and even clarity and so on. But as to the substance of the report, that is the purview of the expert. Now, there's some I had a bit of a look to see. This is a fairly narrow area. There doesn't seem to be many papers that have been done over the last few years. So you'll excuse me if some of these cases you may be familiar with, but I think they're still in this context worth recalling. Now, as Sarah indicated, I acted for Mr. Love. I was fairly junior at the bar, and I got a fairly good grounding in the mechanics of the Act, because Mr. Love used to run some rather interesting and novel interpretations of some aspects of the Act, and I can see some head nodding over there. But certainly there was also, the courts have also had to in one particular case in which Mr. Love in fact appeared for himself in this case before Justice Vickery in Rhodes Corporation and Love. But Justice Vickery had to consider the situation where a group of experts had in fact met. It was in the middle of a series of procedural directions, so some expert evidence had been filed, but there was more to come. And Mr. Love himself had prepared an agenda for the meeting, which was the subject of scrutiny by the courts. Now, I think it's fair to say that whilst Justice Vickery ultimately, and these experts were cross-examined about what happened at the meeting, and there was no adverse finding about any of the experts that fell out of that directly. He did have, I think, the obvious to say that meetings between experts to be called by a party for the purpose of ensuring a common line, and in the case there's a number of vices, the exercise is ultimately self-defeating. The independence of the witness is compromised. The witness is no longer given exclusively his or her own opinion. The evidence is in danger of becoming a team presentation. And I've included a more fulsome extract from His Honour's decision there. And he picks up what was said in Day and Parish of Blue in the New South Wales Court of Appeal, where he observes that it's long been regarded as proper practice for legal practitioners to take proofs of evidence from lay witnesses separately, and that's good practice and ought to be done by all of us. For various reasons, witnesses do not always abide by these instructions, and their credibility suffers accordingly. In the present case, it is hard to see that the intention of the teleconference, once again there was a meeting of experts in that particular case, it was an employment case, discussing among themselves the evidence that they would give was for any reason other than to ensure, so far as possible, that in giving evidence the defendant's witnesses would all speak with one voice about the events that occurred. Don't do it, is the simple message. Secretary to the Department of Business and Innovation and Murdesk Investments. There's a case in 2012. I've got the citation in the paper, where Justice Emmerdon has once again reminded us of the importance of dealing with experts at arm's length. She rejected all of the claimant's value as evidence, and in part as a consequence of the exposure of the history of value as inappropriate contact with the client himself, who was the sole director and shareholder of the claimant in that case. So, for example, Mr. Dickey asked a particular valuer very early on in the piece to increase his valuation from $30 per square metre to $30 to $40 per square metre. In a trial, Mr. Dickinson said that was to give Mr. Dickey some room to move on the compensation case. And there was no proper basis for him in applying his expertise, training and the facts to come to that view. The language used by another valuer, Mr. Holland, and also many of the communications with him were held to be suggestive of collaboration with Mr. Dickey and his advisors to maximise the value of the land. Now, Mr. Dickey essentially treated Mr. Holland as part of the team, and there were a number of contacts with him. He was fed the various iterations of drafts directly to Mr. Dickey, who was providing his review and feedback on those drafts. It's not appropriate. Now, whilst there's nothing wrong per se with evaluation developing over time in an iterative basis, it's the concerted attempt to lift the value by exploring different possibilities with the owner. That's just a no-no. The expert is not an advocate. His or her duty is to the court, and this suggestion of increase of values and changing the substance of his report will eventually be exposed at trial if it gets that far, and it'll compromise the admissibility of the expertise. There's also some findings in relation to another valuer there. The case really highlights that the parties must be careful they don't unduly influence valuers in the course of the report process. To be fair to Mr. Dickey and the legal team, it wasn't an instance so much of dictation as to what, or specifically drafting what the report was, but the valuers succumbed to the suggestion, and that was open, and a finding open to the court, and it was made. Another recent case, again of Justice Emerton, Aldi Foods and Brimbank City Council. That was a rates valuation objection case, and Her Honour was asked to consider certain valuation evidence which had been the subject of a decision at VCAT. Now, she recollected that valuation is not an exact science, it's an estimation, and ultimately the court's process is an evaluative one. And she rejected the evidence of Aldi's valuer, and she did so on a reasonable and rational basis, and there was thus no error of law. But in the course of making that finding, she made this observation. There were two valuers, Aldi and the council. Now, Mr. Sullivan's evidence, O'Sullivan's rather, was for the council, and his evidence was preferred The tribunal concluded that the difference between the approaches was that Mr O'Sullivan relied heavily on statistical data that was not well interpreted and comparisons of pairs of sales that were disparate to produce a most unbelievable downward trend outcome that not even the statistics in his report supported. While Mr Shields, so I've got the values muddled there, so Mr Shields for the council provided a more objective view of the market and discussed a wider range of local sales when compared to the subject site, and its attributes produced a more logical and so a more convincing case for the site value that he is defending. So once again, that wasn't an attack on his particular expertise or his training, but it was his application of the data in expressing the opinion, and there was no proper basis or proper reasoning process that once it was explored at trial and the evidence was rejected. And again, once Her Honour reminded us that it is for the applicant to persuade the tribunal of the reliability of its evidence, and it did not. The tribunal gave rational reasons for rejecting the evidence, and it is not open on this appeal to reopen a judgment which went essentially to questions of weight and persuasiveness. It just again highlights that the parties' representatives need to take great care, not only in instructing experts appropriately, so they have the proper material upon which to express an opinion, but to be objective once the report lands on the desk and consider the views expressed and ensure that their qualifications to express particular views, the methodology that they must articulate in the report, the reasoning and the assumptions are all reasonable and able to be defended at court. Things, for example, valuations at the relevant time that might be obtained in the course of a business, for example, finance applications and so on, are going to be given quite significant weight, particularly where there's a difference between valuations that are later sought to be relied upon in the context of the litigation. And again, there's been some recent comment about purported reliance upon comparable sales that post-date the acquisition date, as opposed to those that precede. And again, the weight that can be given to those or that type of evidence. And also, got to be a bit careful to try and identify when an expert might be trying to, his particular views being invested in his opinion, which removes the objective requirement of his impartial role as an expert whose duty is to the court, because it's going to compromise their independence. Turning to legal costs, because of course in addition to the compensation for the interest acquired, legal valuation and other professional expenses are payable. Tiffany's gone through that process, and I join what she's said. Solicitors for claimants in particular should be encouraged to obtain appropriate evidence, and in my experience the authorities have no difficulty in paying for the cost of obtaining that advice, the valuation planning and other advice that's required, counsel's advice, solicitors' consideration of issues on an indemnity basis. Once, however, the claim becomes referred, we turn to Part 10 of the Act and then the various rules of either the Tribunal or the Supreme Court. Now, in terms of costs themselves, generally they follow the event. The event in this context, of course, being the authority's offer, as compared with the award of compensation ultimately determined by the court or the tribunal. The court or the tribunal, I'll just refer to it as the court, has a general discretion in determining liability for costs under Section 91. That's the general discretion that's reflected also in the Supreme Court Act and the Victorian or the VCAT Act. It provides, however, for certain matters that can be considered in exercising that discretion. The first being the amount of compensation offered by the authority, but secondly, the extent to which the proceedings have arisen from or been affected by the conduct of the parties, and the Act goes through certain examples of that, including unreasonable conduct on the part of the claimant or the authority, and we'll return to that. So that gives rise to, again, so offers in this, I'm going to proceed to now, aren't the statutory offers, and we've been through that process with Tiffany. Offers need to be reassessed once claims are referred and all the evidence is in. That's clear. There are a number of potential avenues one can take to displace the general rule of costs following the event, and they include, in the Supreme Court, offers of compromise under Order 26. In VCAT section 112 to 14 provides the formal requirements for offers in that jurisdiction, and those requirements must be effected in order for an offer to be effective ultimately in assessing the question of costs. And call-to-bank offers, and that's they're informal offers or to the effect, I'm assuming most of us will be familiar with call-to-bank offers. You know, if a judgment one doesn't receive a sum greater than the amount offered, the court may take the offer into account on the question of costs for plaintiffs and the reverse for the defendants. Now, if the question here that the court must consider when looking at a call-to-bank offer is whether the offeree has unreasonably refused the offer. And if so, the court will usually award indemnity costs to the offeror from the date the offer expires. So I've set out in the paper how to construct an effective call-to-bank offer. But how do those processes work in the context of the Land Acquisition and Compensation Act? Now, as a consequence of the statutory open offer process that Tiffany's touched upon, it's for many years been the view that there is no room for informal offers to play any part in the determination of costs in land acquisition matters. And that follows a decision of Justice Gobbo in Coastal Estates and Bass, where he was asked to consider the question of the applicability of Order 26. So that's and Order 26, of course, has again the same rule. If you don't beat the offer, there are cost consequences on an indemnity basis. Now, Justice Osborne in Roads Corporation and Love, and a different decision, 2010 VSC 32, was prepared to distinguish the case of Coastal Estates and awarded indemnity costs against Mr Love from the date that a call-to-bank offer had expired. Now, this was against, as I said, a long standing practice and view that Order 26 certainly couldn't operate along with or so as to override Section 91, as it was inconsistent with it, and that's because of the history of the legislation governing compulsory acquisition, demonstrating the long and special role of open offers and the practice of the court recognising the use and value of open offers. He distinguished open offers from secret offers and held that secret offers were not within the reference to offers in Section 91. Justice Osborne, however, found that unreasonable conduct, which is one of the factors in Section 91 that a court can take into account, may include the unreasonable refusal of a call-to-bank offer. And the Court of Appeal agreed with him. In terms of the importance, though, of both parties looking at their claims once they've been referred to court and the procedural directions have been complied with, there might be some discovery, there's some other reports and other information and evidence available for both parties to reassess their positions and make an offer. The Court of Appeal in that context observed in Love and Roads Corporation that disturbance claims are essentially claims for damages, and the process of trial is attended by risks as to quantum. The very question of land value is one in respect of which reasonable minds might reasonably differ. Once it is accepted that there may be a real risk of substantial costs in litigation, and that is the case, the parties should not be deprived of the opportunity to manage that risk by making without prejudice offers. Thus, the policy underpinning paragraph 91 1b appears to be directed to discouraging the institution or the continuing conduct of litigation, which is either without merit or the conduct of which is prolonged by excessive claims or unreasonable conduct of one sort or another. The court held that the ability to use without prejudice offers once proceedings are referred under the Act is consistent with that policy. And that's so even against the submissions that I had some part in drafting, that a claimant in proceedings under the Act is in the default position that their costs in pursuing a claim ought to be paid. And that's the starting point, and that was accepted by the court for the exercise of the court's discretion and various other matters. Great care needs to be taken in assessing the risks of litigation. The use of informal offers, both in the Supreme Court and in VCAT under section 113 and 14, needs to be used by practitioners in my view, and we can also, it's in my view an essential strategy once claims are referred under the Act. On a final note, there's also now an ability to serve a without prejudice offer, inclusive of costs, which is another way of trying to obtain a settlement, and those offers are also effective once the question of costs are being considered if a claim proceeds to be determined by the court. So thanks for your time. We're going to have a short break now, aren't we, Sarah? Have a cup of tea or whatever, and then we'll return for some questions briefly, because I think we're running a little bit over time.